Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Yesterday, I did a video on Ontario's new stay-at-home order. Today, I'm going to be largely redoing that video because it's become clear that I thought I had the most current version of the order. I did not. So some of the stuff in that video is wrong. This video is probably going to be its own standalone thing, and I will probably take the other one down just to avoid confusing anybody. So let's go through things sort of from the beginning here. This new order includes a whole lot of different stuff, but one thing that was sort of leapt out at me and a bunch of other people and was extremely concerning is this bit here. So to increase public compliance with the stay-at-home order and stop the spread of COVID-19, amendments to an emergency order, and they provide the citation, have been made that will provide police officers and other provincial offences officers enhanced authority to support the enforcement of Ontario's stay-at-home order. Effective Saturday, April 17th, 2021 at 12:01 a.m., so already in effect, police officers and other provincial offences officers will have the authority to require any individual to provide their home address and purpose for not being at their residence. In addition, police officers, special constables, and First Nation constables will have the authority to stop vehicles to inquire about an individual's reasons for leaving their home. This additional enforcement tool will only be in effect during the stay-at-home order and exclusively to enforce the stay-at-home order. So there's a number of things to break down here. First, let's talk about this last bit, because when they say it's only for this one, emergency, well, there's this tendency with rights that they can always sort of point to some big scary thing going on and say, we just need to do something temporarily in order to deal with this problem. And then later they find another thing, and it's probably a less scary thing. It's probably a less serious thing, but they say, well, you guys let us do it for that. We want to do it again for this. And then they find a less scary thing. And eventually they just say, well, this is just the routine. This is just the ordinary. This isn't a violation of anyone's rights. This is just how we operate. And so at that point, the right has effectively vanished. So when they say, oh, we just want to do it this one time, you should be skeptical of that. This is not an argument that we should generally find much favor for. Also, the exclusively to enforce the stay-at-home order. Well, I will tell you, there is no tool that is given to anybody that doesn't get abused in some fashion. When these tools are handed out, they get misused. So they might be using it to enforce the stay-at-home order, or that might be that they want to have a look at somebody's car and be able to ask them some questions and so forth, and, grill them in order to investigate, other possible offenses. So let's go and have a look at this new change to the order, because the text here is going to be important. It's worth looking at. So here is the new amendments to the order. It says, a police officer or other provincial offences officer may require any individual who is not in a place of residence to A, provide the address of the residence at which they are currently residing, and B, provide their purpose for not being at their residence, unless the individual is in an outdoor or common area of their residence. So they can't ask you if you're just, sitting in your yard, or they can't ask you if you're in sort of, if you were in an apartment building that had a pool, some sort of common area like that. They wouldn't be able to ask you why you're not in your place of residence. A police officer, First Nations constable, or special constable, for the purpose of requiring an individual to provide information pursuant to subsection 2, may require the driver of a vehicle to stop, and the driver of a vehicle, when signaled or requested to stop by a police officer, First Nations constable, or special constable who is readily identifiable as such, shall immediately come to a safe stop. And every individual who is required under subsection 2 to provide a police officer or other provincial offences officer with information described in that subsection shall promptly comply. And these powers may only be exercised in a health unit to which Ontario regulation, the stay-at-home order, applies, and may only be exercised for the purpose of determining compliance with Ontario's stay-at-home order. So there's a lot to that. They basically say that they can stop you and require you to provide your address and what you're doing, where you're going, that kind of thing. This is very concerning, because this is basically, they want to be able to stop you and ask you, are you committing an offense? which normally would go against your charter right not to incriminate yourself, and similarly go against your charter right not to be arbitrarily detained. Because, they're just saying, oh, well, we can just detain people just because we see them in order to ask, hey, where are you going? They've eliminated any notion of reasonable and probable grounds. They've eliminated any notion of even reasonable suspicion. It's just the criteria is just, hey, there's a person. I'm going to go and ask them, sir, are you committing an offense? And they're required to answer. And of course, when you're required to answer the officers, you're required to answer truthfully, because lying to the police officer could well constitute the offense of obstruction of justice. So this puts people into a very difficult situation, because now the police are effectively able to compel them to incriminate themselves. And the incrimination might not just be in respect to this regulation, because, for instance, let's say you are off doing something that is otherwise illegal. Normally, you don't have to tell the police that. If you are going off and you are selling drugs and the police ask you, what are you doing? Normally, you don't have to tell them, I am selling drugs today, officer, and it would be a very bad idea to do so. We have charter rights that protect your right not to answer questions like that. It seems that those rights have just evaporated into the wind. Now, you might say, well, who cares about if it's, who cares about somebody not wanting to tell the police that they're doing drugs? But there's all sorts of things you might be outside doing that you might not want to tell the police. I'm going to the doctor. Well, why are you going to the doctor? Is this an emergency? Well, it's my colon. Do you really want to get into that sort of discussion with a police officer? The other thing that occurs to me here is that all of these random stops are now providing additional contacts and additional points of interaction. If you have a police officer standing by the roadside, waving down everybody and bringing them over, that police officer then becomes an infection vector, because every car that's passing by has contact with the police officer, and then that officer has contact with the next car and the next car and the next car. You might as well, it's not quite as much as if you're asking them to share a big glass of spit, but it's still not great. So this to me seems really counterproductive. The next question on a lot of people's minds is going to be, is this constitutional? And that's actually a fairly complicated question, because on its face, certainly this seems to infringe a couple of sections. The section saying that you can't be arbitrarily detained, and the section saying you can't be required to self-incriminate being the most obvious. However, we have Section 1 of the Charter of Rights and Freedoms, which provides that the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So what does that mean? Well, prescribed by law means that it has to be part of the actual law, not just somebody behaving badly. Now, previously I'd made comments on that, but those are out of date because now we've got the order that does prescribe things by law. So the main question here is going to be, is this a reasonable limit on those rights? And the test for that is what's called the Oakes test. And I can't really go through all of the jurisprudence on the Oakes test, but I can give you a brief rundown of what's involved. So the Oakes test involves 4 elements. The first is whether there's a pressing and substantial objective. So that would be, in this case, they'd be saying pandemic. And that probably qualifies as a pressing and substantial objective. I can't see a court saying, nah, that's not something you got to worry about. The next is whether there's a rational connection to that pressing and substantial objective. So, for example, if you imagine an anti-terrorism law that requires you to hop on one foot, the court would probably say those two things are not rationally connected. The one doesn't lead to the other. This is essentially some portion of a test of, does the law do what it says it's going to do? However, the court is going to give a fair bit of deference to Parliament and to government decision makers here, because the courts are not lawmakers. So this is always a bit of a tricky test. I don't know how the rational connection analysis would shake out on this one. I can certainly see arguments for both directions. minimal impairment, which is that it should, in trying to achieve its objective, infringe rights as little as possible, right? So if you imagine an anti-terrorism bill that says you can't leave your house at all without a police escort, that would not be a minimal impairment. That would be a very maximal impairment. So here the question, or one of the questions, will be, could they maybe have not infringed our rights as much? And again, I think that this one could go either way. I can see arguments for both of them. Proportionality is another one, and that is that the benefits gained by meeting the objective should outweigh the harm. So, if you think about it, as a balancing act, it should balance, towards the good things and not the bad. I think this one is going to be a big problem here because the rights in question are actually really substantial and important rights. And the more a particular right is a critical and key issue in our society, the more the courts need to say, listen, there's got to be a really good reason to overcome it. And in this circumstance, it seems like it's very difficult to see how this is going to accomplish their objectives in a real way, in a real sort of substantial way. They might think, oh, well, this could help, but how much is it really going to help? And in fact, as I've suggested, it might actually hurt if you're having all of these people having contact with one person. Like, this seems to me that if that one officer gets infected, then they just infect the whole line. And then those people all go onto their workplaces and infect their workplaces. I'm not sure that part was really thought out all that carefully, especially because I've heard a number of reports of officers, not being the best with the PPE and so forth. So, if you get that as a point of contact, that seems to me to be a bit of a problem. This is a really concerning intrusion because normally we don't have to justify ourselves or what we're doing. Normally we're entitled to privacy with regards to that sort of thing. I may not want to tell an officer where I'm going for a whole lot of reasons. And it may not be, the I'm going out to deal drugs scenario, but the I'm doing something embarrassing, or just the I don't really feel like sharing my day, or I just don't even feel like talking. Also, police interactions are, unnerving. They are threatening. You are being held against your will by an armed person who may well use violence against you if you don't comply. Like, if you don't stop, they're not going to go, oh, hey, goodbye. They're going to follow you along and use violence against you. So, this is inherently a violent action. It's inherently a threatening action. And in particular, people who are in marginalized groups are much more likely to feel this as being an oppressive influence, and also are much more likely to be targeted by these things, because that is what the experience shows, is that if you're in a group that the police don't like, then the police are much more likely to hassle you with this sort of thing. And this basically writes an officer a blank check. If you are a bad officer, you essentially now have a blank check to go hassle people. And it really reduces the tools that they would normally have to tell you to go away. Like, are you writing me a ticket? No? Okay, then I don't want to tell you about my day. I just want to leave. It's not really clear if this is a constitutional law, which means that it's not clear if you can tell the officer to go pound sand. Certainly, if you did that, they're going to write you a ticket here. They've indicated in the press conference that anybody who doesn't answer the questions will be seen to be breaking the law and will be ticketed. So this is very much compelled speech. There's also case law to the effect that where the law does permit compelled speech, which there is some situations where that is the case, that you then can't turn around and use that compelled speech against them in proceedings, which becomes really difficult here because, what are you doing is compelled speech. The example that usually comes up is some provinces have, I'm not sure if it's some or all, but at least some provinces have laws where once you get into a traffic accident, you have to make a report of what happened in that traffic accident. But they may not be able to use that report against you because it's compelled speech. Again, talk to a lawyer if this is coming up and this is your particular circumstances, because I'm just talking about the law. I'm not talking about your specific circumstances, and these rules vary from province to province. But often that compelled speech can't be used against you for instance, a criminal proceeding. So we run into the question of if that applies to this, if we say, well, this compelled speech can't be used to prosecute somebody, what happens if somebody says, listen, you know what? I just got my COVID diagnosis and I really just wanted to go hug some people to infect them. Well, that's compelled speech because we've insisted that they must provide, it creates a bit of an interesting legal, issue. Similarly, what happens if they say, well, officer, I'm required to tell you where I'm going. And where I'm going is I'm going to sell the illegal guns I've got in my trunk to school children. Can the police then rely on that to go and seize the guns and charge the person? Or is that something that's off limits? This is fundamentally very poorly thought out legislation. It's very difficult to see who thought this was a good idea. I have serious problems with this legislation, and from reading the comments on the first video, I'm getting a lot of you do too. So I wanted to follow up here just to make sure that sort of the correct information is out there. I apologize. I may have jumped the gun on the other one, but it appeared that it was the most recent update, so that was not correct. Anyway, thank you for watching. I hope this one has provided you with more enlightening information than the last one did. Please like this video. Please share it with your friends. Please subscribe to see more content. I guess please especially share this one if you shared the other one, because I'm going to be taking that one down, and I hope people will see the correct information here. I also want to thank my Patreon subscribers at the $50 level: Sir Daniel Wicks of Alberta, Jason Elliott, Canada's National Farms Association, North Central Process Service, Kyle Martin, Jean-Guy Toussaint, Ivo Nedevev, CCFR, BCAMF.org, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited, and at the $20 level, Mark Whittington, Dale Nesbitt, Cameron Johnson, Andrew Elsich, Adam Meester, and Marc-Olivier Damour, as well as all of you at the $10 level who will be in the crawl immediately following. Thank you once again for watching, and I hope this has armed you with knowledge.